So I'm going to bring you back down to the Vernon Street reality with a bit of a bang and focus on just the sort of normal, everyday, bread and butter private children law work that we all do. Firstly, focusing on termination of parental responsibility. There's a recent authority by Mr. Justice MacDonald, that's at page 60 in your handout. It's the authority of D&E, and it's a judgment that Mr. Justice MacDonald handed down in April of this year. I would suggest it's a very useful judgment because you get 4 for the price of 1. Because from paragraph 24 of that judgment, he sets out the law for us relating to the termination of contact. From paragraph 28, he sets out the law relating to change of surname. Paragraph 31 onwards, termination of parental responsibility. And from paragraph 36 onwards, the use of a section 9114 application, which of course, Kate mentioned in her talk to you that may actually be an underused resource available to us. So if you're going to read anything, it's maybe worth just having a quick read through those paragraphs because everything you need to know is captured in the one place. Very briefly, the facts of this case related to a girl who I've called Grace, who was 8. Her dad hadn't engaged in the proceedings at all and wasn't represented at the final hearing. Whilst I say he hadn't engaged, he had made noises on the sideline, he had been on the telephone to Grace's solicitor, but hadn't really done anything in any sort of meaningful way. And Grace's mum at final hearing wanted a child arrangements order. She wanted a specific issue order to change Grace's surname. And the children's guardian wanted the 9114 order. And those applications were not there wasn't any controversy. The one that did get the spotlight put upon it, however, was the mother's third application for the father's parental responsibility to be terminated. What Mr. Justice MacDonald tells us is that his starting point was to be completely satisfied that the father knew about the application and that the father had made a choice for whatever reason not to participate. And once the court was satisfied that fairness element had been ticked, the judge was then out of the starting blocks in terms of considering the application. And the reason the mother made the application was because the father had engaged in very serious criminal activity and had a number of convictions, had been in and out of prison. At the start of his offending career, he was having some contact with Grace. But as his offending started to escalate, the mother, on advice from Children's Services, terminated the contact. So at the point the application was before the court, as I said, Grace was 8, but she had last seen her father when she was 2. And during that 6-year period, from the ages of 2 through to 8, her dad hadn't used his parental responsibility in any way to assist her welfare interests. So the mother wanted his parental responsibility to be removed. And in the first instance, her solicitors wrote to the father asking for his consent, which puzzled me a little bit, but maybe the solicitor thought there would be some brownie points received for trying to manage that issue outside of the court arena. Because the father didn't reply, clearly the application then came before the court. So when Mr. Justice MacDonald was determining the application, he started by reminding himself that this father had acquired PR because he was named on the birth certificate and as a consequence, that could only be removed by court order. And Mr. Justice MacDonald went on to say that the child's welfare is the court's paramount consideration, but that the court is not required to consider the factors as set out in the welfare checklist. But he drew on the judgment handed down in Re D back in 2015 that said, whilst there isn't that requirement, it's probably advisable to use the checklist as an analytical framework, not least because welfare has to be considered and reasoned, and also reminded us that the no order principle applies. Mr. Justice MacDonald then went to Re P, which was a 1995 decision, and it effectively encapsulates that once parents or once the father has obtained parental responsibility, it shouldn't be terminated, it shouldn't be removed from him, other than there being solid grounds for doing so. With a presumption that PR will continue rather than any presumption for termination. And so that authority goes on to say that when looking at the child's welfare, the court needs to look for evidence of attachment and a degree of commitment. Mr. Justice MacDonald also drew on the authority of CW, which almost causes the question of termination to be filtered through some time machine, so that the court has to ask the question, well, if the dad was applying for parental responsibility now in 2021, would he get it? And if the answer to that question is a simple no, then that is a factor that the court is to take into account when considering the overall application. So the outcome for that case was that the judge did allow the applications, including the revocation of parental responsibility. And his final remarks on that application were that he asked himself the question, if the father was now applying for an order conferring parental responsibility for Grace, would it be granted? And he said no. But he did also say that terminating parental responsibility is a serious step that must be justified on the available evidence and must be proportionate. The reason I chose this case to chat to you about and bring to life a little bit is I've had recent experience of 4 cases where there has been an application to terminate parental responsibility. So I don't know whether that indicates that there is a growing trend, and I don't know whether with this judgment being published that too is an indicator. It may not be. But I suppose what I want to do is just give you some takeaway points on the back of that authority in case there is a growing trend in these applications. So first and foremost, the application must be on notice. One of the cases I've dealt with recently, the mother raised it as part of her case at final hearing. And similarly to the good practice and guidance that underpins section 9114 applications, that isn't how we make decisions of this magnitude. So first and foremost, on notice. And obviously, if you are the one driving the application, it needs to be on evidence. So it needs to be well reasoned, where you are highlighting that some of those factors that the court is likely to take into account are applicable on the facts of your case. So, for example, has the father got a commitment to the child? Has the father got an attachment to the child? If the father was making an application for PR now, would he get it? And any other relevant factors that you might want to draw upon from the welfare checklist. Looking at it from the other side of the table, if you're on the receiving end of an application, well, again, you want to make sure that you've had proper notice, you've had time to take instructions, and you've had time to put in a response. And I would suggest that even if you have a father who up until this point hasn't necessarily got the tangible evidence to demonstrate commitment or attachment, if he has an intention to do so, then you may want to start to evidence that by making other ancillary applications that build into that framework for establishing that the PR should be retained.